Please be seated. The sitting is open. The court meets today to hear the first round of oral argument of Ukraine. I now give the floor to the agent of Ukraine, Mr. Anton Kornievich. You have the floor, Excellency.
Madam President, distinguished members of the court, I am honored to stand before you in this great hall of justice to represent my country. 573 days ago, Russia launched a brutal, full-scale military assault on Ukraine. This is a war of annihilation. Russia denies the very existence of the Ukrainian people and wants to wipe us off the map. It is a war of imperialism. Russia tries to overthrow our democratically elected government. It is a war of conquest. Russia has attempted to claim Ukrainian territory for itself. And it is a war of atrocity, terror, and war crimes. Mass graves in Bucha, torture chambers in Kherson and Izum, tens of thousands of civilians abducted and held captive. Cities and towns such as Mariupol and Volnovakha completely destroyed, villages flooded, children stolen and deported, deliberate attacks on civilian infrastructure, and many more unspeakable horrors. Yesterday, you didn't hear any of this. Listening to Russia, you would never know what it is doing to my country. But it is a reality. Why does Russia do all of this? In the 21st century, what could possibly justify such barbaric action? Russia has given an answer: a cynical misuse of the Convention on the Prevention and Punishment of the Crime of Genocide. For almost a decade, Russia has been laying the groundwork. Since 2014, Russia has falsely accused Ukraine of committing genocide in violation of the Genocide Convention. On 24th of February 2022, the President of the Russian Federation used that absurd allegation as a sword. He said Russia was acting, it had to act, to stop this genocide. Russia is waging war against my country in the name of this terrible lie, that Ukraine is committing genocide against its own people. This lie is Russia's pretext for aggression and conquest. Russia has presented no credible evidence. It cannot. In reality, Russia has turned the Genocide Convention on its head. The international community adopted the Genocide Convention to protect. Russia invokes the Genocide Convention to destroy. Over the past 573 days, Russia has shown the world what Ukraine already understood. Russia does not respect international law. For Russia, international law is not a constraint. For Russia, international law does not exist to ensure respect for sovereignty and human rights. For Russia, international law is a tool to be abused. Unlike Russia, Ukraine respects international law. Ukraine believes in settling disputes peacefully. That is why, at our moment of greatest peril, Ukraine turned to this court. Your court has broad jurisdiction over disputes relating to the Genocide Convention. The relationship between this dispute and the Genocide Convention is straightforward. Russia accused Ukraine of committing genocide. It launched a full-scale invasion for the stated purpose of stopping genocide. In other words, Russia abused and violated the Genocide Convention by using allegations of genocide as a pretext for a full-scale invasion. But Russia is not above the law. It must be held accountable. Yesterday, Russia told you that this dispute has nothing to do with the Genocide Convention. According to the agent of the Russian Federation, a few Russian officials just, quote, used the word genocide, end of quote. Russia's counsel suggested it was, quote, for rhetorical purposes, end of quote. This is another one of Russia's brazen lies. There is nothing rhetorical about Russia's allegations. For years, Russian state organs declared that Ukrainian high-ranking officials committed the crime of genocide under the Genocide Convention. Senior Russian diplomats declared that Ukraine, the state itself, committed genocide under the Genocide Convention. There was also nothing rhetorical about Russia's violent actions on the basis of preventing and punishing genocide. I would prefer not to quote the President of the Russian Federation. But for 3 hours yesterday, Russia's agent and its counsel were afraid to tell the court what he said. So I will repeat what the Russian President announced on the 24th of February 2022. I quote, "The purpose of this operation is to protect people who, for 8 years now, have been facing humiliation and genocide perpetrated by the Kyiv regime." End of quote. Inside Russia, the express purpose of the full-scale invasion is openly stated at the highest levels. But in this court, it is inconvenient for Russia, so Russia hides from the truth. You were also subjected yesterday to Russia's story of a coup d'etat and the Kyiv regime filled with neo-Nazis who threatened the people in Donbass. These are more lies, but they confirm an important point: there is a dispute. The agent of the Russian Federation even had the audacity to stand in this hall and say that Ukraine was planning a, quote, final solution, end of quote. We all know what those chilling words mean. How can Russia's agent utter those words and then deny that there is a dispute about genocide? This case must proceed to the merits. Then, Russia can try to defend its false claim. If Russia believes its actions are not an abuse of the Genocide Convention, that President Putin didn't mean what he said about genocide, let Russia explain why on the merits. For 9 years, we have endured lies about genocide from the highest level of the Russian government. For 1.5 years, we have suffered terrible attacks because of those lies. Today, Ukraine is simply asking for its day in court so that the court can resolve the dispute. Madam President, members of the court, Russia's disrespect for international law is far-reaching. It includes this court. 18 months ago, this court issued a clear order. Russia must immediately suspend its military operations in Ukraine. But Russia had no interest in complying. Russia immediately announced that it would ignore the binding provisional measures order of the World Court. Russia didn't stop its military operations in Ukraine, as you ordered. To this day, Russia rains down missiles on our cities and our people, still in the name of preventing a purported genocide. The consequences of Russia's defiance have been devastating. An example of this devastation is Russia's deliberate attacks on critical civilian infrastructure. These attacks left entire regions and millions of people without heat or electricity, including in freezing temperatures. The United Nations has documented the grave harm to civilians. This past June, Russia's destruction of the Kakhovka hydroelectric power plant dam in Kherson region caused grave and far-reaching consequences for thousands of people in southern Ukraine, including a lack of access to clean water. Objective international observers have documented this devastation. The World Bank has calculated that the damage Russia has inflicted on Ukraine will require $411 billion to repair. The UN Human Rights Council's Independent International Commission of Inquiry on Ukraine has found that Russian forces committed a wide range of violations of international law, many war crimes and acts that may amount to crimes against humanity. One example, Russia's military operations in the area of the Zaporizhia nuclear power plant, which risk a serious nuclear incident, gravely endangering civilians. Another horrifying example is the forcible deportation of Ukrainian children. I quote what the Minister for Foreign Affairs of Ukraine, Dmytro Kuleba, said in July, and I quote, "To date, we have identified 19,474 illegally transferred kids, including 4,390 who are orphans or lack parental care." End of quote. For these shocking acts, the International Criminal Court issued arrest warrants. It found reasonable grounds to believe that the head of state of Russia, who sits on the UN Security Council, is personally responsible for these war crimes. This is how Russia is willing to go. On the pretext of preventing genocide, it commits the war crime of forcibly transferring children from their homeland. It is not just Ukraine that suffers from such terrible acts. By blockading Ukrainian ports and threatening international shipping, Russia has destroyed or held hostage millions of tons of grain, worsening global food shortages in Africa and beyond. Russia's defiance is also an attack on this court's authority. Every missile that Russia fires at our cities, it fires in defiance of this court. Just last week, Russia attacked a market in Konstantinivka, killing 17 people, including a child. Every one of these victims was killed because of Russia's defiance to this court. Every child that Russia has deported, it deported in defiance of this court. And every brave Ukrainian defender that Russia maims or kills, it has maimed or killed in defiance of this court. Your provisional measures order is another inconvenient topic for Russia. Yesterday, it said almost nothing about it. When Russia did acknowledge your order, Russia didn't hesitate to tell you that you were wrong. But Russia's opinion doesn't change its international obligations. Your order is binding. Russia openly defies it. This court now has the opportunity to reject such defiance. You have the power to ensure that international obligations are meaningful. You can decide that states that tirelessly abuse and misuse a human rights treaty will be held to account. You have the power to declare that Russia's actions are unlawful, that its continued abuses must stop, that your orders must be followed, and that Russia must make reparation. 1 year ago, President Volodymyr Zelensky said to the UN Security Council that in Ukraine, I quote, "Not only our independence is being defended, not only the right to life for our people, but also international law as such," end of quote. In this court as well, international law as such is at stake. Ukraine urges the court to reject Russia's abuse of international law. Ukraine asks you to ensure that the Genocide Convention remains a force for protecting human rights, not a means for denying millions of people their human rights. Yesterday, you heard Russia twist the facts and distort the law. Today, Ukraine will explain why this court can and must hear Ukraine's case on the merits. Professor Charlotte Honju-Ko will first address the interpretation of Article 9 of the Genocide Convention and the broad jurisdiction it confers on this court. He will explain why Russia cannot escape this court's jurisdiction by mischaracterizing Ukraine's claims. Ms. Marnichik will then show that there is a dispute between the states relating to the Genocide Convention. Professor Jean-Marc Touvenin will demonstrate that this dispute falls squarely within this court's jurisdiction, ratione materiae. Mr. David Zients will address why Ukraine claims are admissible. Finally, Mr. Jonathan Gimblet will discuss this court's jurisdiction to address the Russian Federation's ongoing and flagrant violations of this court's order indicating provisional measures. Madam President, members of the court, on the ashes of World War II and the Holocaust, the world produced a landmark human rights treaty in the Genocide Convention. It reflects the highest ideals of humanity. A few months from now, the world will mark this convention's 75th anniversary. This can be an opportunity for the international community to recommit itself to the convention's civilizing aims and humanitarian purpose. But if Russia's abuse goes unanswered, this anniversary will be a dark one. Can it truly be the case that a state can abuse the Genocide Convention to justify a war of conquest? Can a state use false allegations of genocide as a pretext to destroy cities, bomb civilians, and deport children from their homes? And when the Genocide Convention is so cynically abused, is this court powerless? The answer to these questions must be no. It must be no for the sake of the Ukrainian people, who remain under brutal attack. And it must be no for the sake of the world, to prevent international law from being twisted into a tool for human rights abuses and destruction. Ukraine is grateful for the court's attention this morning. Madam President, I now kindly ask you to call Professor Ko to the podium.
I thank the agent of Ukraine for his statement, and I now give the floor to Professor Harold Hongju Ko. You have the floor, Professor.
Madam President, members of the court, it is again my honor to appear before you on behalf of Ukraine. In February 2022, shortly after Russia's full-scale invasion, Ukraine brought before you this dispute relating to Russia's false allegations to justify its unilateral actions in and against Ukraine on the pretext of preventing and punishing a genocide. When Russia ratified the Genocide Convention in 1954, it consented to this court's jurisdiction over any dispute relating to the interpretation, application, or fulfillment of the convention. Yesterday, Russia's counsel denied that there is an ongoing dispute that brings this case within Article 9 of the convention. Russia takes one position. Because Ukraine is responsible for committing genocide, they say, it must use military force to prevent and punish that alleged genocide in violation of the convention. But Ukraine takes the opposite position. It strenuously disputes Russia's outrageous claims, rejects Russia's claimed right and duty to use force to stop this claimed genocide, and shows that it is Russia that has abused, misused, and violated the convention by invading Ukraine on the pretext of genocide prevention. Yesterday, in their oddly antiseptic presentation, Russia's counsel repeatedly denied that it had invoked the Genocide Convention to authorize the use of force. But they ignored President Putin's own words launching the invasion, where he explicitly declared the purpose of this special military operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kyiv regime. To this end, Russia will seek to demilitarize and denazify Ukraine, as our agent has just recounted, by using brutal force for the last 19 months. As defined in Mavramatis, a dispute is a disagreement on a point of law or fact, a conflict of legal views or of interest between two persons over which this court may exercise jurisdiction. Here we clearly have such a disagreement relating to the interpretation, application, or fulfillment of the convention. So under Article 9, that brings this case squarely within your jurisdiction. When we first appeared before you last March seeking provisional measures, this court found by a vote of 13-2 that in the court's view, the acts complained of by Ukraine appear to be capable of falling within the provisions of the Genocide Convention. Upon closer examination, this court's prima facie ruling was plainly correct and should lead you now to dismiss Russia's preliminary objections. Dismissal is required first because of Article 9's distinctively broad scope, which reflects the importance and purpose of the Genocide Convention itself. Second, because Russia cannot avoid the court's manifest jurisdiction by grossly mischaracterizing Ukraine's claims, ignoring settled jurisprudence, and asking you to disregard the facts and evidence Ukraine has offered and will prove at the merits stage. Madam President, members of the court, the treaty's text, object and purpose, negotiating history, and historical context all show that Article 9 was intended to grant the court jurisdiction over the widest range of disputes relating to the Genocide Convention, including this dispute. In their presentation yesterday, Russia's counsel glided over the specific and distinctive language of Article 9, the Convention's dispute settlement provision, which you see here. Russia ignores four ways in which Article 9 is both distinctive and broader than other such clauses, because the Genocide Convention is a broad and distinctive treaty. First, and most obvious, the clause does not confine itself to cases concerning interpretation or application of the treaty, as many such clauses do. It also includes disputes relating to whether and how parties like Russia have fulfilled their treaty obligations. During the drafting debates, after the Indian delegation made clear that fulfillment has a much wider meaning than application, the delegations defeated a proposal to delete fulfillment, confirming their intent to adopt the broadest formulation possible. The Oxford English Dictionary defines fulfillment as accomplishment, performance, completion. In French, Larousse defines l'exécution as the performance or accomplishment of an obligation. So adding the word fulfillment to the familiar template of interpretation and application was designed to ensure that the court's jurisdiction would reach disputes relating to the ways in which the contracting parties, like Russia, perform or accomplish their obligations under the convention. When Russia invaded Ukraine last February for the pretextual reason of stopping a genocide, it failed to perform in good faith. In fact, it abused the convention. Contrary to what Russia's counsel asserted yesterday, this case differs significantly from the legality of use of force case, where no party stated before the court that the use of force by the respondent states had the purpose of preventing an alleged genocide. In contrast, as Judge Nolta observed in his separate declaration to the Provisional Measures Order, Russia has in the present case, quote, made allegations that Ukraine is committing genocide and has affirmed that its special military operation serves the purpose of preventing genocide, thereby, quote, acting in a way that is capable of coming within the provisions of the Genocide Convention. So the plain text of Article 9 thus authorizes this court to review Russia's violations of the Genocide Convention on the merits. To be clear, this is a dispute not just about the convention's fulfillment, but also about its interpretation and application. This dispute is about interpretation because the parties disagree about the meaning of their respective legal rights and obligations under the convention. This dispute is about application, as the Chorzo factory case explained, because application includes disputes related to whether the application of a particular clause has or has not been correct, and whether a state has created a situation contrary to said articles. Here, Russia has clearly misapplied the convention by abusing the text and purpose of this treaty to launch an unlawful military invasion. So even if Article 9 had the same narrower scope as many other compromissory clauses, this dispute would still fall squarely within it. But the unusual addition of the word fulfillment gives Article 9 its distinctively comprehensive sweep, placing this court's jurisdiction beyond any doubt. Second, Article 9 extends jurisdiction to disputes relating to the interpretation, application, or fulfillment of the convention. It does not require that treaties' interpretation, application, or fulfillment alone be the subject matter of the dispute. The ordinary meaning of relate, as defined by the Oxford English Dictionary, is to have a connection with something. In the Yakimet's case, which addressed whether the UN Administrative Tribunal had erred on a question of law relating to the provisions of the UN Charter, Judge Schwabel explained that such an error need not squarely and directly engage a provision of the Charter. It is sufficient if such an error is connected with the Charter. Here, Russia's pretextual allegations that Ukraine committed genocide in violation of the Convention, which Russia used as its basis for violently invading Ukraine, obviously are connected with, that is, relate to, the responsibility of a state for genocide, genocide prevention, and genocide punishment. Third, Article 9 specifies that it includes those particular disputes relating to the responsibility of a state for genocide. As this court observed in the Bosnian genocide case, this clause is an unusual feature of Article 9, you said. The word including tends to confirm that disputes relating to the responsibility of the contracting parties for genocide are comprised within a broader group of disputes relating to the interpretation, application, or fulfillment of the Convention. That broader group of disputes would include, for example, the questions relating to responsibility for genocide here. Is Ukraine, as Russia alleges, really responsible for committing genocide? Or is it Russia that violates its duties under the Convention by falsely alleging that Ukraine is committing genocide, then invoking that pretext to invade and brutalize its sovereign neighbor? Fourth, Article 9 specifies that any of the parties to a dispute under the Convention may submit it to the court. Article 9 imposes no preconditions, leaving no doubt. It was meant to ensure broad access to the court. So, if, as Russia acknowledges, a state that levels allegations of genocide against another can ask the court to resolve that dispute, there is no reason why a state such as Ukraine that disputes allegations of genocide against it and illegal actions based on pretextual allegations cannot do the same. Article 9's four unique textual features were not accidental. As Professor Kolb describes in the Gaeta commentary to the Genocide Convention, the drafters deliberately decided to close down all possible loopholes, weakening the jurisdictional reach of the court, so as to grant the court as wide a jurisdiction as possible in the life of the convention. But yesterday, Russia asked you to undo that careful drafting decision by narrowing what the drafters meant to broaden and reopening the very loopholes they meant to close. As the written interventions of the intervening states confirm, the intentional breadth of this court's jurisdiction flows not just from the expansive language of Article 9, but also from the Genocide Convention's broad object and purpose. Genocide is the worst crime in international law and human history. It is the ultimate crime, the kind of horrible, intentional effort to destroy an entire national, ethnic, racial, or religious group that we have witnessed all too often in our collective past. The Convention's preamble sets out its historic purpose as a good faith endeavor of international cooperation to liberate humankind from this odious scourge. As this court stated in its landmark 1951 advisory opinion, the Convention was manifestly adopted for a purely humanitarian and civilizing purpose. Conferring broad Article 9 jurisdiction on this court helps to achieve that object and purpose, which yesterday Russia's counsel claimed that, quote, Russia stands by. A genuine good faith determination that genocide or a serious risk of genocide exists may empower preventive action consistent with international law, which must not be exercised lightly. Because along with that power comes the responsibility to avoid abusing it and degrading the jus cogens norm against genocide that the Convention protects. States offend the object and purpose of the Convention when they ignore a genocide that is clearly occurring, but also when they falsely allege a genocide that is clearly not occurring, not to achieve the Convention's humanitarian purposes, but to seek license to illegally attack and invade another state. Both kinds of disputes unmistakably relate to the interpretation, application, and fulfillment of the Convention, including the responsibility of a state for genocide. The extreme facts of this case show the grave danger of allowing Russia to subvert the Genocide Convention's noble purposes. Article 9 gives this court a crucial role, not just when a state violates the Convention by committing genocide, but also when it misinterprets it, misapplies it, or falsely claims to fulfill its treaty obligations by inflicting grievous harm on a neighboring nation and people. The many interventions that you will hear tomorrow announce that this case is far bigger than Ukraine versus Russia. It is about what the world's most important human rights treaty really means, how it may be lawfully used, and whether this court is powerless when that convention is flagrantly abused. Madam President, members of the court, Russia's presentation yesterday sought to avoid Article 9's broad sweep by mischaracterizing this dispute as one that relates to whether Russia's recognition of the so-called Donetsk and Luhansk People's Republics complied with customary international law and whether its use of force against Ukraine complied with the UN Charter. But we all know Russia only took those actions on the pretext that the invasion of Ukraine was necessary to prevent and punish genocide. The real dispute that Ukraine has put before you, not the one that Russia has manufactured, relates to the questions of interpretation, application, or fulfillment of the Genocide Convention raised by Russia's invocation of its false allegations to justify its pretextual unilateral actions, including sham recognition and use of force and atrocity in the name of self-defense. Ukraine claims that Russia violated Article 1 of the Convention by acting on the false allegation that Ukraine committed the international crime of genocide, which Russia became obliged to prevent and punish. Ukraine further claims that Russia violated Article 4 by invading Ukraine to punish a genocide based on false allegations that Ukraine officials are persons committing genocide for purposes of Article 4. At this preliminary objection stage, this court, not Russia, must isolate the real issue and objectively determine the subject matter of the dispute, taking particular account of the facts on which Ukraine, as applicant, rests its claim. Russia may disagree with Ukraine's position on the merits. It may wish to defend its outrageous allegations that Ukraine and its officials committed genocide. It may wish to deny that these allegations had anything to do with its brutal, full-scale invasion. If so, Russia can make those empty arguments at the merits stage. But for now, these merits arguments are irrelevant to the only thing that matters at this stage. Ukraine and Russia undeniably have a dispute over which this court has jurisdiction under Article 9. Yesterday, you repeatedly heard Russia justify its actions under customary international law or Article 51 of the UN Charter. But it does not matter whether Ukraine and Russia also have a dispute that relates to other sources of international law. As this court recently made clear, certain acts may fall within the ambit of more than one instrument. And as this court elaborated in another case between these same two parties, the fact that a dispute before the court forms part of a complex situation that includes various matters, however important, over which the states concerned hold opposite views, cannot lead the court to decline to resolve that dispute, provided that the parties have recognized the jurisdiction to do so. Madam President, members of the court, in a great many cases, you are asked to decide close and difficult questions. But this is not one of them. When we first met here at the Provisional Measures hearing, you clearly understood the dispute before you. Ukraine charged Russia with launching a full-scale invasion of Ukraine on the pretext of preventing and punishing a claimed genocide that transparently is not occurring, and invoking a convention that conferred no lawful authority upon Russia to invade Ukraine, kill its citizens, and destroy its homeland. Russia acted and continues to act based on false allegations of genocide against Ukraine and twisted readings of the law, both of which Ukraine disputes. Simply put, Ukraine and Russia have a dispute relating to the interpretation, application, or fulfillment of the convention that this court must decide. Russia's allegations and actions give rise to this court's jurisdiction, full stop. Accordingly, this court should dismiss Russia's preliminary objections and proceed to the merits. Madam President, I now ask you to call Ms. Cheek to the podium to explain why Russia's first preliminary objection should be dismissed.
I thank Professor Foe, and I now invite Ms. Marnie Cheek to address the court. You have the floor, Madam.
Madam President, members of the court, it is an honor to appear again before you on behalf of Ukraine. This morning, I will address Russia's first preliminary objection regarding the existence of a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention. Russia's first preliminary objection should be rejected. In the first instance, Russia is wrong on the law. Russia has departed from this court's test to determine whether a dispute exists between the parties. That test focuses on the parties' opposing views regarding the subject matter of the treaty. Second, Russia is wrong on the facts. The evidence before the court confirms the existence of a dispute between the parties relating to the Genocide Convention. There is no question that at the time of Ukraine's application, the parties held opposing views on Russia's reliance on allegations of genocide to justify its unilateral actions in and against Ukraine for the stated purpose of bringing an alleged genocide to an end. I will first turn to the legal test this court applies to determine the existence of a dispute between the parties. The legal test is well settled, and normally we would not need to spend much time on it. But Russia has urged the court to adopt a radically different approach, and it is therefore worth taking a few minutes to clarify the standards that have been consistently applied by your court. Yesterday, Russia's counsel focused on the submissions in Ukraine's memorial and asked this court whether a dispute between the parties existed as to each of those submissions. But respectfully, this is the wrong approach. Ukraine's application invokes a single treaty, the Genocide Convention, and the question before the court is whether a dispute exists regarding the subject matter of that treaty. The standards the court applies to determine whether a dispute exists regarding the subject matter of a treaty are well established. The court has consistently emphasized that the existence of a dispute should be determined objectively on the basis of the facts before the court. The existence of a dispute is a question of substance, not of form or procedure. And such an assessment takes account of the statements of the parties as well as the parties' conduct. The court has consistently applied these standards. They are set out in Georgia versus the Russian Federation, Marshall Islands versus the United Kingdom, and alleged allegations, Nicaragua versus Colombia, to name a few. It is of particular note that the court recently applied these standards in its judgment on preliminary objections in the Gambia versus Myanmar, a case also under the Genocide Convention. Now, Russia does embrace some aspects of the court's settled jurisprudence, observing that a dispute exists where, quote, the claim of one party is positively opposed by the other, and, quote, a dispute exists when the respondent was aware or could not have been unaware that its views were positively opposed. At the same time, however, the Russian Federation seeks to impose novel requirements, many of which this court has considered previously and rejected. Russia's main argument is that at the time of Ukraine's application to this court, Ukraine's legal claims must have been identified with exacting specificity. This is the foundation of Russia's first preliminary objection, and was echoed yesterday as Russia's counsel took you to the submissions in Ukraine's memorial, rather than focusing on the subject matter of the Genocide Convention. Russia asks this court to focus on whether Ukraine articulated specific legal claims under the Genocide Convention, ignoring whether a dispute existed relating to the subject matter of the convention. Russia argues, for example, that, quote, Ukraine must demonstrate that an dispute existed with respect to each of the claims formulated in the memorial at the time that Ukraine filed its application. Russia also suggests that the evidence of a dispute must reflect quote, positively opposed views with respect to the specific obligations under the convention. But the court has previously rejected that proposed test. In the Gambia versus Myanmar, Myanmar argued, as Russia does here, that statements made prior to the Gambia's application did not specifically articulate its legal claims. As Russia does now, Myanmar argued that prior to instituting proceedings, the applicant must have identified the provisions of international law that have been breached. Your court rejected this argument. The court explained that it, quote, does not consider that a specific reference to a treaty or to its provisions is required. The court went on to say that a state must only, quote, refer to the subject matter of the treaty with sufficient clarity to enable the state against which a claim is made to identify that there is or may be a dispute regarding that subject matter. Contrary to Russia's presentation yesterday, the focus of the court is on the existence of a dispute with regards to the subject matter of the treaty. Russia's allegations of genocide against Ukraine and its unilateral actions for the stated purpose of bringing that genocide to an end fall squarely within the subject matter of the Genocide Convention, the commission of genocide and the prevention and punishment of that heinous crime. This court has consistently found the existence of a dispute in a wide range of circumstances. In the Gambia versus Myanmar, for example, the Gambia had made 2 statements before the United Nations, neither of which referred expressly to the Genocide Convention, which this court found were opposed by Myanmar and sufficient evidence of the parties' dispute under the convention. In Georgia versus the Russian Federation, Georgia never expressly referred to the Convention on the Elimination of All Forms of Racial Discrimination in exchanges between the parties before Georgia seized the court under that treaty. Nevertheless, the court concluded that Georgia's statements made in the course of Russia's August 2008 invasion, though, quote, primarily claims about the allegedly unlawful use of force, also expressly referred to allegations of ethnic cleansing by Russian forces, end quote. The court found that Georgia's statements referring to ethnic cleansing in this context were sufficient evidence that there was a dispute under the CERD. In short, this court has established that when determining whether a dispute exists, the focus is on whether there were communications regarding the subject matter of the treaty at issue. The parties do not need to refer to the treaty by name. There is certainly no requirement to expressly reference specific treaty provisions or legal sections. Perhaps realizing the weakness of this principal legal argument that Russia puts forward, Russia attempts to erect a series of additional technical legal hurdles. But these efforts similarly run afoul of the court's jurisprudence and should therefore be rejected as well. First, Russia argues that a dispute between the parties relating to the Genocide Convention cannot exist because Russia never formally invoked Ukraine's responsibility for genocide under the Convention. On this basis, Russia asked the court to simply disregard Russia's statements accusing Ukraine of committing genocide and Russia's express reliance on those allegations to justify its recognition of the DPR and LPR and its full-scale invasion of Ukraine. Russia claims to find support for its argument in the International Law Commission's articles on responsibility of states for internationally wrongful acts, which Russia also referenced yesterday. But the commentaries to the ILC articles on invocation of state responsibility specify that they, quote, are not concerned with questions of the jurisdiction of international courts and tribunals, or in general with the conditions for the admissibility of cases brought before such courts or tribunals. The court also rejected the respondents' reliance on the ILC articles in Marshall Islands, observing that, quote, the court's jurisprudence treats the question of the existence of a dispute as a jurisdictional one that turns on whether there is, in substance, a dispute, not on what form the dispute takes or whether the respondent has been notified. Similarly, the court should reject Russia's novel proposal in this case. Second, Russia asks the court to ignore the conduct of the parties. Specifically, Russia asks the court to ignore Ukraine's conduct, demonstrating its rejection of Russia's claimed right to invade Ukraine for the stated purpose of preventing and punishing a genocide. But this court has previously confirmed that the conduct of the parties may be relevant to its assessment of whether or not a dispute exists, particularly in cases where, for various reasons, there have been no diplomatic exchanges between the parties. For example, in Marshall Islands, in this court's discussion of Bosnian genocide, the court noted that, quote, in that particular case, which involved an ongoing armed conflict, the prior conduct of the parties was sufficient to establish the existence of a dispute. As I will shortly demonstrate, the parties' conduct in this case also underscores the existence of a dispute here. Simply put, Russia's attempt to erect as many legal hurdles as possible to this court finding the existence of a dispute should be rejected. To summarize, the court's jurisprudence is clear. The court looks objectively at the facts to determine whether, at the time Ukraine filed its application, a dispute existed between the parties relating to the subject matter of the Genocide Convention. The court does not require the articulation of specific legal claims by Ukraine in order to find a dispute. Nor does the court require that Russia must have formally invoked Ukraine's international responsibility under the Genocide Convention for this case to proceed. In making its assessment, the court should take into account both statements and conduct. With this in mind, we turn to the facts before you. Russia has repeatedly accused Ukraine and its officials of committing genocide in the Donbas region of Ukraine. Russia then relied on those allegations of genocide in February 2022 to recognize the DPR and the LPR and to justify Russia's full-scale invasion of Ukraine. Russia has made these accusations of genocide for years, sometimes referring expressly to alleged violations of the Convention, sometimes referring to the subject matter of the Convention without calling the Convention out by name. Russia cannot deny these statements, and so it claims they have no significance. The world was in shock when Russia launched its full-scale invasion of Ukraine in February 2022. But the steps culminating in that brazen use of force did not only include a buildup of troops along the Ukraine-Belarusian border. It also included 8 years of building a sham justification for Putin's so-called special military operation, allegations that Ukraine had committed genocide in Donbas that must be prevented and punished. This was not just political rhetoric, as Russia would like you to believe. I will now walk you through a bit of that 8-year history. You heard little yesterday about the investigative committee of the Russian Federation. Since 2014, the investigative committee has repeatedly and expressly alleged that Ukrainian officials, including 2 ministers of defense, have committed crimes under the Genocide Convention. The investigative committee has pursued criminal proceedings against Ukrainian officials based on alleged acts of genocide against the Russian-speaking population of eastern Ukraine. As you may recall, the investigative committee is a state organ of the Russian Federation, and it is supervised by the President of the Russian Federation. Let me highlight just a few specific statements made by Russia's investigative committee. You will also note that the committee repeatedly refers to the Genocide Convention by name. In September 2014, the committee claimed that, quote, in violation of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, unidentified persons from among the top political and military leadership of Ukraine gave orders aimed to completely destroy specifically the Russian-speaking population living on the territory of the Donetsk and Luhansk republics. In January 2015, the committee stated that the actions of top political and military leadership of Ukraine, quote, can only be qualified as genocide, and that such acts carried out by the Ukrainian military constitute especially grave crimes, not only under Russian law, but also under the norms of international law, in particular, the Convention on the Prevention and Punishment of the Crime of Genocide. In September 2017, the committee announced 20 criminal cases against Ukrainian officials, including the sitting Minister of Defense. It alleged that they acted, quote, in violation of the Convention on the Prevention and Punishment of the Crime of Genocide by giving deliberately criminal orders to shell civilian infrastructure. The committee stated that, quote, it is obvious that all of these persons acted out of hatred to the Russian-speaking population living in the Donbass, wishing them to die. Make no mistake, these allegations are false. Ukraine unequivocally denies them, but they also clearly involve the subject matter of the Genocide Convention. And as I will get to in a moment, they also have been opposed by Ukraine, both through its words and its actions. In December 2019, in a press release that marked the anniversary of the adoption of the Genocide Convention, the Russian Investigative Committee explained that, quote, guided by the norms of both national and international law, investigators, of course, cannot stand aside while acts of genocide are. Accordingly, it added that it was, quote, investigating crimes of genocide of the Russian-speaking population of Donbass, where civilians are dying at the hands of the Ukrainian military under targeted fire. Now, Russia claims that these statements by its investigative committee cannot form the basis of a dispute with Ukraine relating to the subject matter of the Genocide Convention. According to Russia, these statements do not represent the position of the Russian state on, quote, the international level, as the investigative committee was merely conducting a national investigation. Although yesterday Russia did concede that these investigations relate to the, quote, international crime of genocide. There is no legal requirement that statements be made on, quote, the international level. But in any event, Russia's argument that the investigative committee was doing nothing but a domestic investigation rings hollow. The investigative committee is a Russian state organ that has leveled inherently international allegations against Ukrainian officials, crimes under the Genocide Convention. And as a factual matter, the investigative committee has represented Russia at the international level, attending, for example, formal bilateral negotiations between Ukraine and Russia. And the investigative committee itself has trumpeted its allegations of genocide to the international community. For example, in 2016, the investigative committee hosted a formal presentation in English for foreign diplomats aimed at sensitizing international and foreign communities to the problem of combating international crimes in Ukraine, and they discussed the possibility of submitting evidence gathered by the Russian investigative committee to the bodies of international justice to determine the Ukrainian government's responsibility for internationally wrongful acts. Russia cannot seriously ask this court to find that it never made allegations of genocide at the international level. Beyond the investigative committee, countless Russian officials, including President Putin himself, have leveled the same accusation that Ukraine is responsible for genocide, often specifically referencing the convention. And Russian officials have explicitly referenced that these allegations of genocide justify their recognition of DPR and LPR and their full-scale invasion of Ukraine. For example, in November 2021, 3 months before Russia's recognition of DPR and LPR and its full-scale invasion, Boris Gryzlov, Russia's representative to the Trilateral Contact Group on settling the situation in Ukraine, justified Russia's support for DPR and LPR by referencing, quote, Kyiv's actions, which are aimed at escalating the conflict and actually fall within the UN Convention on the Prevention of Genocide. As an aside, I would note that that statement made by Russia's envoy to the Trilateral Contact Group was most certainly a statement at the international level. I also would note that Mr. Gryzlov referenced the Genocide Convention by name. Since 2014, as you have seen, Russia has alleged that Ukraine was committing genocide in violation of the convention. And at the end of February 2022, Russia went further. It took two extraordinary measures on the express basis of preventing and punishing an alleged genocide in Donbass. These actions were opposed by Ukraine, and these actions happened with startling speed. First, on the 21st of February 2022, President Putin formally recognized the independence and sovereignty of the DPR and LPR. In an address given on that day, President Putin claimed it necessary to take a long overdue decision to immediately recognize the independence and sovereignty of the DPR and LPR. Why? Because of a, quote, genocide, which almost 4 million people are facing in the DPR and the LPR. This was the same justification that Russia's permanent representative to the United Nations, Vasily Nebenzia, provided to the United Nations General Assembly. On the 23rd of February 2022, Mr. Nebenzia justified Russia's recognition of the DPR and LPR by claiming that, quote, in light of the blatant genocide, Russia could no longer remain indifferent to the fate of 4 million people of the Donbass. In other words, Russia justified its recognition of the DPR and LPR as a measure to bring an alleged genocide to an end. What happened the next day, on the 24th of February, 2022, is known to us all. President Putin announced his so-called special military operation, which was, in fact, a full-scale invasion of Ukraine. Yesterday, Russia was selective in quoting the speech of its president. Russia noted President Putin's reference to Article 51 of the UN Charter and its treaties of friendship with the DPR and LPR. But President Putin's speech did not end there. In his very next sentence, President Putin stated the purpose of his military intervention, the justification for his actions. And that justification was to stop a genocide. He stated, quote, we had to stop that atrocity, that genocide of the millions of people who live there and who pinned their hopes on Russia, on all of us. Putin went on, the purpose of this operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kyiv regime. The express purpose of Russia's invasion, according to Russia's president, was the prevention and punishment of a genocide that Russia alleged was occurring in eastern Ukraine. Russia transmitted President Putin's address in its entirety to the UN Security Council. Following this address, Russian officials echoed the justification for Russia's actions set out by their president. For example, this time speaking to the UN Security Council, Russia's UN permanent representative stated that President Putin, quote, decided to start a military operation in Donbass and that the goal of this special operation is protection of a people who have been exposed to genocide by the Kyiv regime. Russia's official representation to the United Nations was that its actions in Ukraine were justified in order to protect those in Donbass from an alleged genocide. The following day, on the 25th of February 2022, Russia's Foreign Minister, Sergei Lavrov, similarly justified Russia's aggression against Ukraine as, quote, preventing the neo-Nazis and those who promote methods of genocide from ruling this country, referring to Ukraine. And in an interview that same day, Russia's ambassador to the European Union was asked about President Putin's reference to genocide as a justification for his invasion of Ukraine. The ambassador said, quote, we can turn to the official term of genocide as coined in international law. If you read the definition, it fits pretty well. the ambassador was clear. Russia does not use the term genocide for rhetorical purposes. It uses the term as it is formally defined in international law, in other words, as that term is defined in the Genocide Convention. Ukraine did not remain silent in the face of Russia's allegations of genocide and its reliance on them to recognize the DPR and LPR and invade Ukraine. Ukraine positively opposed both Russia's allegations of genocide and Russia's steps to prevent and punish alleged genocide on Ukraine's territory. From the very beginning, in 2014, Ukrainian officials denounced the allegations of genocide put forward by Russia and Russia's investigative committee. For example, in October 2014, then President of Ukraine, Petro Poroshenko, commented on the decision of the investigative committee to open a criminal case against the military leadership of Ukraine for the alleged genocide of the Russian-speaking population of Donbass. The President of Ukraine rejected the premise of the investigative committee's case, stating, quote, "I am sure that the blow to Russian-speaking people was inflicted by the northern neighbor," pointing a finger at Russia. The Prosecutor General's Office of Ukraine also stated that the investigative committee's actions were, quote, "groundless." And one of the Ukrainian officials accused by the investigative committee, then Minister of Defense, Mr. Valery Zhelety, publicly rejected the committee's allegations. He stated, "Regarding the criminal case against me and my colleagues in Russia for genocide of the Russian-speaking population, this whole thing is a complete delusion." Minister Zhelety added that, quote, "Only crazy Kremlin propagandists can accuse the Ukrainian army, which is 40% Russian-speaking, of hating other Russian speakers." Minister Zhelety's sentiment was echoed by advisors to the Ukrainian Minister of the Interior, who also denounced the actions of the investigative committee as nonsense. As one advisor responded, quote, "I have to tell you that commenting on another nonsense of the investigative committee of the Russian Federation is a thankless task, especially when they use terms like genocide." In November 2015, following additional allegations of genocide by the investigative committee, Ukraine's Speaker of the Presidential Administration on Anti-Terrorist Operational Issues explained that the Russian side is fabricating data about Ukraine's alleged genocide of the Russian-speaking population in Donbass. In an effort to undermine the relevance of these Ukrainian statements refuting Russia's allegations of genocide, Russia argues that these Ukrainian officials do not have authority to represent Ukraine's position at the international level. Further, according to Russia, Russia could not have been expected to be aware of these statements. In other words, Russia looks for any way it can to say that Ukraine did not actually oppose Russia's baseless view that Ukraine was committing genocide against its own people. But these efforts by Russia to ignore evidence of a dispute between the parties falls flat. Ukraine has presented numerous examples of statements made by Ukrainian officials, including Ukraine's president and its Minister of Defense, rejecting Russia's allegations. These statements were reported on government websites, in the press, and on social media. Russia could not have been unaware that Ukraine opposed its allegations of genocide. To this day, the investigative committee continues to levy accusations against Ukrainian officials. Ukraine, already on the record opposing these allegations as fabrications, nonsense, and a complete delusion, saw no need to give Russia's propaganda more legitimacy by continuing to condemn Russia's allegations. Ukraine's position was clear. And then, in late 2021 and early 2022, as Russia amassed troops along the Ukrainian border, its alleged allegations of genocide took on a new and more sinister significance. Russia's propaganda machine was in full swing. Ukraine responded. On the 26th of January 2022, the Information Agency of Ukraine's Ministry of Defense published an article responding to Kremlin propaganda myths in which it stated, quote, "There is no evidence that Russian-speaking or ethnic Russians in eastern Ukraine are persecuted, not to mention genocide, by the Ukrainian authorities." On the 23rd of February 2022, at the same UN General Assembly meeting where Russia's permanent representative to the United Nations claimed that Russia's recognition of the DPR and LPR was in response to a blatant genocide, Ukraine's Minister of Foreign Affairs, Dmytro Kuleba, denounced Russia's accusations against Ukraine as absurd. Russia is critical of the fact that Minister Kuleba's statement did not explicitly refer to genocide or the Genocide Convention. But while Minister Kuleba chose not to amplify Russia's accusations of genocide, he very clearly and forcefully defended his government's actions in Donbass and condemned Russia's illegal recognition of the DPR and LPR. And the next day, Russia launched its full-scale invasion of Ukraine, the purpose of which, according to President Putin, was, and I quote, "to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kyiv regime." Russia acted on a purported right under the Genocide Convention to use force to prevent, punish, and bring to an end an act of genocide in Ukraine. Russia immediately opposed Russia's reliance on allegations of genocide to invade Ukraine. Ukraine opposed Russia's position with a sense of urgency as bombs rained down on Ukrainian cities and Russian troops invaded from the east, the north, and the south. Ukraine did first and foremost through its actions. Ukraine resisted Russia's purported fulfillment of the Genocide Convention in the strongest terms, defending its territory and its people, including in the Donbass region, from Russian aggression. Was Ukraine protecting its territorial integrity? Absolutely. But in doing so, Ukraine was also rejecting the notion that Russia had the authority to use force in and against Ukraine to stop a genocide. In this case, as in Bosnian genocide, which also involved an ongoing armed conflict, the parties' conduct demonstrates a dispute relating to the Genocide Convention. At this point, there was a dispute between the parties relating to the Genocide Convention that included Russia's reliance on its fabricated allegations of genocide to justify its recognition of DPR and LPR and its full-scale invasion of Ukraine. The opposing positions of the two states had been established by the statements and the conduct of each party, and no further action was required by either Ukraine or the Russian Federation to bring the dispute within the ambit of Article 9 of the Genocide Convention. Lest there have been any doubt, however, Ukraine reiterated its opposition before filing its application with this court. In a statement by Ukraine's Ministry of Foreign Affairs, published on the 26th of February 2022, on the third day of Russia's full-scale invasion and prior to filing Ukraine's application with this court, The Ministry of Foreign Affairs again rejected Russia's narrative, publishing a statement on Russia's false and offensive allegations of genocide as a pretext for its unlawful military aggression. In this statement, the ministry explained that, quote, Ukraine simply denies Russia's allegations of genocide and denies any attempt to use such manipulative allegations as an excuse for unlawful aggression. The ministry went on, the crime of genocide is defined in the Genocide Convention, and under that convention, Russia's claims are baseless and absurd. Russia's claims of genocide as justification for its lawless conduct are an insult to the Genocide Convention and to the work of the international community in preventing and punishing the world's most serious crime. The ministry called on Russia to immediately cease aggression against Ukraine taken under this pretext. Russia claims that Ukraine's statement was imprecise or vague, but that's disproven from the statement's plain language. As to timing, given the fast pace at which Russia's full-scale invasion was unfolding, with Russian troops attempting to take Kyiv and bring down Ukraine's government, the timing and manner of the statement's publication do not detract from its relevance in confirming that there is a dispute existing related to the Genocide Convention at the time of Ukraine's application to this court. It is common ground that Ukraine published this statement prior to filing its application. It is reasonable to presume that in the circumstances of war, the Russian Federation would have been closely monitoring any official statements from Ukraine's Ministry of Foreign Affairs. Finally, I would direct this court's attention to the subsequent conduct of the parties in this case. In the Gambia versus Myanmar, the court observed that, quote, conduct of the parties subsequent to the application may be relevant for various purposes, in particular to confirm the existence of a dispute. After Ukraine's application, and after the court indicated provisional measures in this case, the Russian Federation maintained its claim that its actions in and against Ukraine are based on bringing an alleged genocide to an end. In remarks given on the 18th of March 2022, just 2 days after this court indicated provisional measures, President Putin reiterated that people in Donbass were subject to genocide, and he claimed that, quote, the main goal and motive of the military operation that we launched in Donbass and Ukraine is to relieve these people of suffering of this genocide. Just this summer, the Secretary of Russia's Security Council explained again that, quote, the special military operation has specific goals, and that Russia is, quote, saving the population of the DPR and LPR from the genocide that has been carried out by Ukrainian neo-Nazis for 8 years. If any possible doubt remained, it was put to rest 2 weeks ago by a statement by Dmitry Medvedev, the Deputy Chairman of Russia's Security Council, and formerly Russia's President and Prime Minister. Medvedev stated, the UN Convention on the Prevention and Punishment of the Crime of Genocide states that genocide is understood to mean acts committed with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group as such. This is exactly what the Kyiv regime has been doing since 2014. Medvedev went on, using a derogatory term meaning Ukrainian scum, and I quote, the convention also states genocide must be justly punished. Ukrainian scum who are guilty of killing civilians in Donbass will receive a well-deserved punishment for everything they have done. That is why the special military operation must go on until its goals are fully achieved. That's a chilling statement, but it is also quite clear. To conclude, since 2014, the Russian Federation has accused Ukraine and its officials of committing genocide in Donbass in violation of the Genocide Convention. Ukraine called such allegations a complete delusion. But Russia did not back down. Instead, it relied on those allegations of genocide to justify its recognition of DPR and LPR and to launch a full-scale invasion of Ukraine. Ukraine protested vehemently. It protested before the UN General Assembly through statements by its Ministry of Foreign Affairs and by fighting against the Russian incursion. Russia, to this day, continues to allege that genocide justifies its war. It continues to invoke the subject matter of the Genocide Convention and to even call out the Genocide Convention by name. Madam President, members of the Court, the facts speak for themselves. There is a dispute between these parties relating to the Genocide Convention, and Russia's first preliminary objection must be denied. I now ask that you call Professor Jean-Marc Tuvenen to the podium to address Russia's second preliminary objection.
To take the floor, the Court will observe a coffee break of 10 minutes. The sitting is adjourned. Please be seated. The sitting is resumed. I shall now give the floor to Professor Jean-Marc Touvenin. You have the floor, Professor.
Merci beaucoup, Madame la Présidente.
Thank you, Madam President. Madam President, distinguished members of the Court, it is an honor to appear before you to represent Ukraine, and I am grateful for Ukraine's trust. I will deal with the second preliminary objection, according to which the Court lacks jurisdiction ratione materiae to make a determination in the instant case. Despite Russia's long developments, which I will deal in the alternative by giving the appropriate construction of Articles 1 and 4 of the Convention, you will easily reject this jurisdictional objection as it is clearly lacking merit. Madam President, distinguished members of the Court, Russia's argument in order to mislead you regarding your jurisdiction ratione materiae is that, according to its interpretation of the Convention, which it asked you yesterday to approve, the Convention does not apply to the facts reported by Ukraine. That is Russia's argument. Thus doing, it is simply asking you to exercise your jurisdiction fully and make a determination on the dispute pertaining to the interpretation of the Convention, although this dispute is indeed at the heart of the instant case. To be perfectly logical, you should reject this objection just as you did in the Bosnian genocide case, considering that, and I quote, "It is sufficiently apparent from the very terms of that objection that the parties not only differ with respect to the facts of the case, their imputability and their applicability to them of the provisions of the Genocide Convention, but are moreover in disagreement with respect to the meaning and legal scope of several of those provisions, including Article 9. For the Court, there is accordingly no doubt that there exists a dispute between them relating to the interpretation, application, or fulfillment of the Convention." End of quotation. I could leave it at that, but I shall now demonstrate in the alternative that this dispute meets the other jurisdiction ratione materiae tests, which you first applied in the oil platforms case, and this without needing to interpret Articles 1 and 4 of the Convention. Even more in the alternative, were you to decide to proceed at this stage to the interpretation of those articles, you would conclude that it confirms that you do have jurisdiction ratione materiae to make a determination on the instant case. Madam President, in cases not related to the Genocide Convention, the Court has affirmed on more than one occasion since the oil platforms case that, and I quote, "In order to determine the Court's jurisdiction ratione materiae under a compromissory clause concerning disputes relating the interpretation or application of a treaty, it is necessary to ascertain whether the acts of which the applicant complains fall within the provisions of the treaty containing the clause." End of quotation. Applying this test, assuming it is relevant, would therefore mean, 1, to take the facts reported by the applicant as alleged. It is not a matter of determining if these allegations are credible or not. The point is to take the alleged facts as they have been formulated by the applicant. The appreciation of evidence is left for the merits. Secondly, in light of these allegations, the court must determine if the dispute concerns the interpretation, application or fulfillment of the Genocide Convention, including state responsibility regarding genocide. The facts alleged by Ukraine are known. Russia has falsely accused Ukraine of committing or allowing genocide to be committed, with the aim to justify its action in and against Ukraine, claiming it is an action to prevent and punish this purported genocide. Thus doing, Russia claims it was acting out of a sense of duty. As the Provisional Measures Order states, the President of the Russian Federation stated that Russia had to stop a genocide against millions of people, and that it would seek the prosecution of those who had committed numerous bloody crimes against civilians, including citizens of the Russian Federation. End of quotation. To give even more weight to this purported compelling duty, the Russian president stated at the very time he launched his military operation in and against Ukraine that, and I quote,
"Responsibility for the possible bloodshed will lie fully and wholly with the ruling Ukrainian regime. We all know that having justice and truth on our side is what makes us truly strong." Fin de citation.
End of quotation. 3 days before this statement, the Russian head of state had criticized other states for not having done their own duty to prevent and punish the purported genocide in Ukraine.
Old civilized world, disait-il, which our Western colleagues proclaim themselves the only representatives of, prefers not to see this, as if this horror and genocide, which almost 4 million people are facing, do not exist. But they do exist. How long can this strategy continue? How much longer can one put up with this? Fin de citation.
End of quotation. These are the alleged facts. Russia has accused Ukraine of committing genocide, of not having prevented this genocide, of not having prosecuted the perpetrators. It also accused the international community of refusing to act to put an end to this purported genocide. And then it considered that his duty act to prevent and punish this purported genocide gave it a correlative right to do so, including by using armed force. This is exactly what President Putin said to justify his special military operation, a quotation we've already heard this morning, but I would like to remind you of yet again.
Of this operation is to protect people who, for years now, have been facing humiliation and genocide perpetrated by the Kyiv regime. To this end, we will seek to demilitarize and denazify Ukraine, as well as bring to trial those who perpetrated numerous bloody crimes against civilians, including against citizens of the Russian Federation. Fin de citation.
Russia tells another story, claiming that it acted out of self-defense. In other words, the facts alleged by Ukraine are simply not plausible. But this is clearly a defense on the merits, as Professor Coe has already explained. Indeed, as the court has stated in its jurisprudence on jurisdiction ratione materiae, its task is not, at the stage of preliminary objections, to determine if the facts alleged by the applicant have been established. Quite to the contrary. And here I quote the court, "At the present stage of the proceedings, an examination by the court of the alleged wrongful acts or of the plausibility of the claims is not generally warranted. The court's task, as reflected in Articles 79 of the Rules of Court, etc., is to consider the questions of law and fact that are relevant to the objection to its jurisdiction." End of quotation. So an examination by the court of the alleged wrongful acts or of the plausibility of the claims is not warranted. You only need to determine if the acts of which the applicant complains, as I just recalled them, fall within the provisions of the treaty. In other words, if the dispute in question does indeed fall within the provisions of Article 9 of the Genocide Convention. I would add that Russia cannot rewrite Ukraine's application and claim that its real object bears no relation whatever to the Genocide Convention, but aims to challenge Russia's right to self-defense. This argument is worthless. Firstly, because the submissions Ukraine wishes the court to approve refer to violations of the Genocide Convention, and secondly, that the court has already determined that, and I quote, the court's duty to isolate the real issue in the case and to identify the object of the claim does not permit it to modify the object of the submissions, especially when they have been clearly and precisely formulated. End of quotation. Madam President and distinguished members of the Court, with all due respect to Russia, the claims made by Ukraine are what they are. To ensure they fall within the provisions of the treaty, the Court stated in the past that, and I quote, this may require the interpretation of the provisions that define the scope of the treaty. End of quotation. Thus, all that is required is to interpret Article 9. This article states that your jurisdiction encompasses all disputes relating to the interpretation, application or fulfillment of the present convention. Yet this dispute clearly relates to the interpretation, application or fulfillment of the convention. Might I recall that Ukraine has stated, amongst others, that Russia gravely misused the convention by justifying its unilateral action in and against Ukraine as an action to prevent and punish an imaginary genocide. Yet, it has already been determined that a dispute relates to the abusive interpretation, application, or fulfillment of a convention, and whether that falls within the court's jurisdiction, ratione materiae. In the judgment on the preliminary objections in the first Equatorial Guinea France case, the court determined that, quote, any argument in relation to abuse of rights will be considered at the stage of the merit in this case. End of quotation. Besides, Article 9 also provides, and this is unusual in the compromissory clause, also provides that your jurisdiction encompasses disputes relating to the responsibility of the state for genocide or for any of the other acts enumerated in Article 3. And your court has already stated that, and I quote, the reference in Article 9 to the responsibility of the state for genocide or for any of the other acts enumerated in Article 3 does not exclude any form of state responsibility. Any form of state responsibility. End of quotation. Yet, the instant case is quite clearly a dispute relating to state responsibility with regard to genocide, as Professor Krog has already recalled. Yet again, this is enough to reaffirm that you do have jurisdiction ratione materiae to entertain this dispute on the merits. Madam President, distinguished members of the Court, I would now like to move on in the alternative to the interpretation of the other relevant provisions of the Convention, in particular Articles 1 and 4, although I believe you need not do this in order to affirm your jurisdiction ratione materiae. First of all, I would note that your provisional measures order gives enough indications to clarify the meaning and scope of these provisions, and I shall read this out. In accordance with Article 1 of the Convention, all states parties thereto have undertaken to prevent and to punish the crime of genocide. Article 1 does not specify the kinds of measures that a contracting party may take to fulfill this obligation. A contracting party may resort to various means of fulfilling its obligation to prevent and punish genocide that it believes to have been committed by another contracting party. The Court emphasizes that, in discharging its duty to prevent genocide, every state may only act within the limits permitted by international law, as was stated in a previous case brought under the Convention. The acts undertaken by the contracting parties to prevent and to punish genocide must be in conformity with the spirit and the aims of the United Nations as set out in Article 1 of the United Nations. It is doubtful that the Convention, in light of its object and purpose, authorises a contracting party's unilateral use of force in the territory of another state for the purpose of preventing or punishing an alleged genocide. End of quotation. Is there more to be said? Ukraine believes that there is not. The explanation provided by your court have fully resolved this issue. But Russia contends, and this is one of the key elements of its preliminary objections, that although the Convention does not authorize the unilateral use of force to prevent and punish a purported genocide, it does not prohibit the use of force. Madam President, distinguished members of the Court, Ukraine most certainly does not argue that the Genocide Convention prohibits all unilateral use of armed force by a state against another state. This issue does not arise in the instant case. Ukraine contends that the use of armed force against a state with a view to preventing and punishing an entirely imaginary genocide is a serious abusive use and a serious violation of the obligations and rights provided by the Convention. This leads us to the substantive issue raised. Is a state in breach of its obligations regarding the application and fulfillment of the Convention if it uses armed force against another state in order to prevent and punish a fictitious genocide? Ukraine submits that this is unarguably the case. And I shall now go into this particular issue by interpreting the Articles 1 and 4 of the Convention.
As the Court is well aware, these provisions establish, and to use the Court's words, this provision establishes rights and obligations erga omnes. Under Article 1, the parties undertake to prevent and to punish genocide, which means that they should put an end to genocide that is being committed and punish the perpetrators, or prevent a genocide from being committed if there is a proven risk. As the Court stated under this provision, and I quote, "The contracting parties have a direct obligation to prevent genocide," end of quotation. And states have, and I quote once again, "the obligation to take such action as they can to prevent genocide from occurring, while respecting the United Nations Charter and any decisions that may have been taken by its competent organs," end of quotation. Furthermore, and I quote, "The obligation each state thus has to prevent and to punish the crime of genocide is not territorially limited by the Convention," end of quotation. This last point is indeed what makes this Convention so unique. In fact, the Court has already held that this obligation goes beyond what is stated expressis verbis. Therefore, it also logically includes the obligation for state parties not to commit genocide. Ukraine holds that it also includes, just as logically, the prohibition of the use of force against another state under the false pretext that it has committed genocide, which under Article 1 should be prevented and punished. On the other hand, Article 4 states that persons committing genocide or any of the other acts enumerated in Article 3 shall be punished whether they are constitutionally responsible rulers, public officials, or private individuals. State parties thus have the obligation to punish persons having committed genocide and other related acts. It follows from obligations imposed on each state to prevent and punish genocide wherever it has been committed or wherever it is committed, including on the territory of a third state, that states have a corresponding right to put an end to genocide and to punish its perpetrators. This is the meaning of the court's words when it constructed the convention as establishing the rights and obligations erga omnes. The rights in question form an enabling rule, as it is called in English, in that the convention authorizes every state to implement, and I would like to quote the quote here, means that are reasonably available to them, end of quotation, to prevent and punish genocide where it has occurred, including outside its territory. In other words, the recognition of a risk that genocide may be committed, or and even more so, that genocide is being committed, leads to a legal consequence under Article 1, not only to the obligation for all states to prevent it or to act in order to put an end to it, but it also leads to a right to take action to prevent it. And in this sense, the resolution of the international law adopted in the Krakow session in 2005 confirms under its Article 1 that a breach of an obligation erga omnes enables, this is the term that was used, enables other states to react, enables other states to react. In the preparatory report of the resolution, Professor Giorgio Gaia also stated that, and I quote in English,
obligation erga omnes, all the states to whom the obligation erga omnes is owed have a corresponding right. Fin de citation.
End of quotation. In the Genocide Convention, this right authorizes states to implement an effective action to prevent and punish genocide, and the state on which this is committed, whether it's prevented or committed. In Gambia versus Myanmar, the court confirmed that it's any state party to the Genocide Convention, not only a specially affected state, may invoke the responsibility of another state party with a view to bring that failure to an end. End of quote. Madam President, Russia's assertions, according to which Articles 1 and 4 contain obligations but not rights, is this assertion that Russia has made is fundamentally erroneous. While it is true that the Genocide Convention fixes duties and correlative rights to prevent and punish genocide, it also fixes legal limits to the actions that can be undertaken to do so. These limits do not fall outside the scope of the Convention, as Russia claims. In fact, they arise from the texts of Articles 1 and 4 when they're read in good faith and supported by well-established principles and established principles of international law, and when they're read in light of the object and purpose of the Convention. So what are these limits? First of all, it is obvious that state parties cannot invoke and fulfill their rights and obligations under the Convention in a manner which would be contrary to its object and purpose, or for purposes that are contrary to those for which the Convention was adopted. Indeed, as the Court stated in its order indicating provisional measures, Article 1 of the Convention, and I quote the Court, does not specify the kinds of measures that a contracting party may take to fulfill this obligation. End of quote. Article 1, therefore, gives parties a discretionary power. But such a discretionary power is precisely not without limits. And in this respect, the court has, and I quote, repeatedly stated that where a state possesses a discretionary power under a treaty, such a power must be exercised reasonably and in good faith. End of quotation. The most striking example of misuse of such a power is when a state falsely claims that genocide was committed and is being committed in or by another state with the sole aim of exercising the supposed right to act to the detriment of that state, including by using force against it. And such conduct would constitute an obvious breach of the obligation to perform the Convention in good faith. Article 26 of the Vienna Convention on Treaty Rights reflects this rule, since it provides that, and I quote, every treaty in force is binding upon the parties to it and must be performed by them in good faith. And for its part, the court has judged that, and I quote, the principle of good faith obliges the parties to apply the treaty in a reasonable way and in such a manner that its purpose can be realized. End of quotation. Needless to say, the obligation to apply the treaty in good faith is inherent to any treaty, in that even if the treaty has no provisions specifically stipulating this, it is still an obligation under the Convention. And it is particularly true for the Genocide Convention, since Article 9 provides that disputes on the application or the fulfillment of the Convention can be brought before the court. This necessarily includes disputes on the application or fulfillment of the Convention that are not in good faith and in clear contradiction with its object and purpose. It follows a minima that the assessment of the commission of genocide or of a risk of genocide with the aim of justifying the need to take action must be carried out with due diligence before this action is undertaken to prevent or to punish it. In other words, an allegation of genocide should not be a mere pretext to justify a supposed right to act to the detriment of third states. According to the court, and I quote, a state's obligation to prevent and the corresponding duty to act arise at the instant that the state learns of, or should normally have learnt of, the existence of a serious risk that genocide will be committed. End of quotation. Again, according to the court, when the determination of the existence of a genocide risk is required, I quote, the notion of due diligence, which calls for an assessment in concreto, is of critical importance. End of quotation. The preamble of the Convention states that international cooperation is a necessity to end the scourge of genocide, and other provisions of the Convention, such as Article 8, that calls on states to use multilateral mechanisms. This strengthens the obligation of due diligence that falls on the state that intends to conduct unilateral action to put an end to what it claims to be genocide committed in or by another state. The travaux préparatoires confirm that the Convention does not authorize states to harm other states under the pretext of preventing and punishing genocide that has not been established or whose risk has not been seriously assessed. The negotiators of the Convention rejected a proposal that provided for the protection of political groups because it was considered as a very convenient pretext for interference in the international affairs of states. As to the proposal aimed at penalizing all forms of political propaganda aimed at inciting racial, national, or religious enmities or hatreds, or at provoking the commission of acts of genocide, this proposal was rejected because it could become a pretext for serious abuses, and this is, of course, from the travaux préparatoires. The fact that the amendments that might have provided pretext for serious abuse was rejected confirms that the negotiators had no intention of tolerating that a state seriously abuses Articles 1 and 4 of the Convention. Madam President, distinguished members of the Court, with regard specifically to the abuse of rights conferred by the treaty, the Court deemed that it is constituted when a state seeks to exercise rights conferred on it by this treaty for purposes other than those for which the rights at issue were established. End of quotation. In this case, contrary to what you heard at nauseam yesterday, Ukraine does not contend that Article 1 of the Convention confers the right on states to use. Excuse me, Madam President, says Professor Tuvna. I will repeat this. In this case, contrary to what you heard ad nauseam yesterday, Ukraine does not contend that Article 1 of the Convention confers the right to the use of force. It contends that Article 1 authorizes states to take certain actions that it does not define. In other words, it confers the right to act and prevent genocide on states, and it is indeed this right that Russia has misused to justify the actions that Ukraine contests. Actions that obviously have nothing to do with the purposes for which this right was provided. Furthermore, contrary to what Russia asserts in its submissions, there is no doubt that misuse of a right can constitute a breach of that treaty, and in the certain German interests case, the Permanent Court of International Justice had acknowledged that, and I quote, misuse of the right conferred by the Treaty of Versailles could have the character of a breach of the treaty, end of quote. And more recently, when in the certain Iranian assets case, when the court's jurisdiction was based on the compromissory clause of a bilateral treaty that contained no provision prohibiting misuse of a right, the court did not consider that it lacked jurisdiction, ratione materiae, to entertain the claim of misuse of rights enshrined in the said convention, and therefore it judged the merits of the case. The same holds, as I already mentioned, in the Equatorial Guinea versus France, in the first case. In any case, Article 9 of the Convention, the Genocide Convention, provides express jurisdiction to the court in disputes on the fulfillment of the Convention. And this, as the court said, necessarily implies the need of taking into account the disputes on misuse of obligations and rights derived from the Convention, and that the concerned state claims to fulfill. Russia has outrageously misused the Convention to justify what the Convention cannot in any way justify. It has alleged the existence of an imaginary genocide in Ukraine as a pretext to justify its action in and against Ukraine. There cannot be a more serious misuse of the rights and obligations under the Convention. This claim falls within the provisions of the Convention, and the court has jurisdiction, ratione materiae, to rule on the merits of this case. Madam President, distinguished members of the court, this court recalled in the order indicating provision measures that, and I quote, that every state can exercise its obligations within the limits of international law. And we can say that this is a modality of the obligation not to misuse the rights and obligations that the Convention confers on states, as I just mentioned, because that would be a misuse of the Convention to use it as a tool to breach international law. And in this respect, the limit constituted by the lawfulness of the decision constitutes abuse. But this limit is also independent of the abuse of or misuse of the right, and is an inherent condition of Articles 1 and 4 of the Convention. And in this regard, in contrary to what Russia claims, the terms chosen by the court to qualify these limits are crystal clear. A state cannot, which means that it does not have the right to deploy any action based on its obligations under the Convention, and that it is authorized to take to prevent or punish genocide that goes beyond what is permitted by international law. By asserting this, neither the court nor Ukraine are incorporating obligations that do not exist in the Convention. On the contrary, the only possible way to interpret the Convention is to understand that it requires that the duties and rights that it establishes should be fulfilled with measure, that is, within the limits of international law. As the court asserted, and I quote, "The high ideals which inspired the Convention provide, by virtue of the common will of the parties, the foundation and measure of all its provisions." End of quote. There is no comparison between this case and the oil platforms case, or the certain Iranian assets case, or the first Equatorial Guinea versus France case. It is the Convention itself, interpreted in good faith in light of its object and purpose, and the high ideals that it pursues, that poses a limit to the unique rights that the Convention confers on states, limits whose contents are determined by international law. There is no other way of interpreting the Convention. The Convention is an instrument, as its preamble states. It is an instrument that is aimed at ridding humanity of a crime under international law, or freeing humanity from one of the most heinous scourges. It cannot be a tool that enables the justification of crimes under international law and the proliferation of the most heinous scourges. The purely humanitarian civilizing purpose of the Convention, to use the court's words, beautiful words I might add, prohibit such an interpretation or construction. Madam President, distinguished members of the court, this concludes my oral statement today. I request you to give the floor to Mr. David Zients. Thank you.
Thank you, Professor Tuvanen. I now invite Mr. David Zients to address the court. You have the floor, sir.
Madam President, members of the court, it is an honor to appear before you today on behalf of Ukraine. I will address Russia's 4 admissibility objections. None of these objections has any sound basis. All of them are just another artificial attempt by Russia to escape the broad jurisdiction conferred by Article 9 of the Genocide Convention. Russia's 3rd preliminary objection is that Ukraine's memorial advances new claims. It contends that Ukraine's application was limited to, quote, a request to confirm that the Russian Federation's actions had no basis in the Convention, end quote. According to Russia, Ukraine's memorial goes beyond that by seeking, quote, to establish the responsibility of the Russian Federation for allegedly violating Articles 1 and 4 of the Convention. End quote. Russia is wrong on both the facts and the law. Part 4 of Ukraine's application states the grounds of Ukraine's claims. It concludes, quote, the Russian Federation's declaration and implementation of measures in the form of a so-called special military operation, as well as acts of recognition based on a false claim of genocide, is incompatible with the Genocide Convention and violates Ukraine's rights, end quote. And in Part 5 of the application, Ukraine requested that the court declare that Russia, quote, cannot lawfully take any action under the Genocide Convention in or against Ukraine aimed at preventing or punishing an alleged genocide on the basis of its false claims of genocide, end quote. A claim that Russia's actions are incompatible with the Convention, that they violated Ukraine's rights, that Russia's actions are not lawfully taken, is unmistakably a claim that Russia violated the Convention. The court understood the nature of Ukraine's case in its provisional measures order, summarizing Ukraine's position as follows, quote, "The Russian Federation has acted inconsistently with its obligations and duties as set out in Articles 1 and 4 of the Convention," end quote. For this basic factual reason, Russia's third preliminary objection is baseless. But Russia's objection also flouts the law for three reasons. First, as the court explained in the first Nicaragua versus Colombia case, even if a claim is new, that does not, in itself, render the claim inadmissible. A new claim is inadmissible only if it transforms the subject matter of the dispute. And as explained in certain phosphate lands, a claim does not transform the dispute if it is at least implicit in the application or arises directly out of the question, which is the subject matter of the application. The subject matter of this dispute is, and always has been, the same: Russia's reliance on allegations of genocide to justify harming Ukraine. Yesterday, Russia dissected the words of Ukraine's submissions, but it missed the point. Each submission arises directly out of Russia's actions in reliance on its allegations of genocide. As I have explained, Ukraine's application asked for more than a declaration that Russia's actions lacked a basis in the Genocide Convention. But even if that had been the sole request, the question of whether Russia's actions could be justified under the Convention is closely related to whether those same actions violate the Convention. They stem from the same dispute. Second, Russia improperly focuses on the wording of Ukraine's request for relief. It is common practice for parties to adjust their submissions as a case proceeds. Freedom to do so may not be limitless, as Russia's counsel says, but neither are the submissions written in stone. In Nicaragua, at the second round of written pleadings on the merits, Nicaragua, quote, changed the solution being sought, i.e., its requested relief. The court still rejected Colombia's admissibility objection. Ukraine's adjustments to its submissions here are far less dramatic. Russia emphasizes the phrasing of the application's request for a declaration that Russia's actions have no basis in the Convention. Yet, it ignores Ukraine's separate request for a declaration that Russia cannot lawfully take the action it was taking. And it ignores the application's legal claim that Russia acted inconsistently with its obligations under the Convention. Against this background, it was unremarkable and not remotely a transformation for Ukraine to clarify in its memorial that it requested a declaration of Russia's violation. Similarly, Russia notes that the application requested a declaration that no acts of genocide have been committed by Ukraine, while the memorial, it points out, seeks a declaration that there is no credible evidence that Ukraine is responsible for committing genocide in violation of the Genocide Convention. Both formulations arise from the same dispute with the same subject matter: Russia's reliance on false allegations of genocide without credible evidence to take harmful action against Ukraine. Ukraine's application discussed this lack of evidence for Russia's allegations. And the fact that Russia acted against Ukraine without any such evidence is relevant to Ukraine's claim of abuse, also an integral part of Ukraine's application. Incorporating this point into Ukraine's submissions does not transform the dispute. Third, Russia faults Ukraine for not expressly referencing Article 4 in its application. Article 4 concerns the punishment of, quote, persons committing genocide, end quote. Ukraine claims that Russia improperly sought to punish Ukraine and its officials as persons committing genocide, even though they are not such persons. Again, this claim arises directly out of the subject matter of the application: Russia's actions taken for the express purpose of preventing and punishing genocide. In sum, Ukraine has in no way transformed the dispute. Russia barely engages with the question of transformation, instead mechanically comparing word choice. That has never been this court's approach. This case, where the court has already found that Ukraine prepared its applications in circumstances of extreme urgency, should not be the first to adopt Russia's rigid methodology. Madam President, members of the court, Russia's fourth objection fares no better. Russia contends that the court could not deliver an effective judgment because, in Russia's unilateral opinion, Ukraine's claims are, quote, based on rules of international law that are beyond the convention, end quote. As my colleagues have explained, this is not true. Ukraine's claims are based firmly on the Genocide Convention. Once its mischaracterization of the dispute is set aside, Russia's fourth objection falls alongside its others. At most, the Russian Federation debates the precise scope of appropriate relief. Russia seems to suggest that even if its actions are found unlawful under the Genocide Convention, it would be free to continue invading Ukraine on some purported alternative basis. Russia's argument is wrong, but more importantly for today, it is premature. Russia has not established that it is impossible for any judgment to have any purpose. At this stage, that is more than enough. If Ukraine prevails, the court can at minimum adjudge that Russia abused and violated the Genocide Convention. It can order non-repetition. It can order reparation for the consequences of the violation. A judgment would further establish, at minimum, that Russia may not use force to prevent and punish an alleged genocide in Ukraine, which Ukraine alleges was and is the stated purpose for Russia's actions. A binding judgment of this court holding Russia accountable would undoubtedly be meaningful. Once the case proceeds to the merits, Russia is free to argue that its actions were unrelated to preventing genocide. If Russia believes that it can continue its actions for a different purpose, different than the one it has stated, and that this might affect the scope of relief, Russia is free to present that argument as well. But none of this makes it inevitable that any possible judgment would be devoid of purpose. Russia asks you to entertain these merits defenses now, apparently because they assert in the strongest possible terms that they are so obviously correct. In the view of Russia's counsel yesterday, quote, the Genocide Convention plays no role in its military operation, clearly and manifestly, end quote. But whatever Russia's counsel says, on the day Russia launched its full-scale invasion, the president of the Russian Federation said that its purpose was to stop a genocide. And just 2 weeks ago, a high-ranking Russian official reaffirmed the reason Russia's military action continues: to punish perpetrators of genocide as required by the Genocide Convention. The court should listen to Russia's leaders, not its lawyers, and consider whether it is really so clear and manifest that the Genocide Convention plays no role in Russia's actions. The circumstances here are nothing like the cases Russia draws on for support. In northern Cameroon sought a declaration about the United Kingdom's obligations under a trusteeship agreement that was no longer in force and expressly disclaimed any claim for reparation. In the nuclear test cases, Australia and New Zealand asked the court to order France to stop nuclear tests. And France, at the highest levels of its government, made a binding undertaking to do so. So there was nothing left for the court to order. Further adjudication would have been, as the court put it in those cases, devoid of purpose. Here, the Genocide Convention remains in effect. Every day, Russia continues to abuse and violate the Convention by acting against Ukraine for the stated purpose of preventing and punishing a falsely alleged genocide. And Ukraine requests reparation for those abuses and violations. Russia may deny these claims, and it may oppose this relief. But that only confirms that there is a live dispute, and that your judgment will matter. Madam President, members of the court, I turn to Russia's fifth preliminary objection, which concerns only one of Ukraine's requests for relief, a declaration on the lack of credible evidence that Ukraine is responsible for committing genocide. Russia calls this a reverse compliance request. A better description is that Ukraine asks the court to resolve a disputed question of responsibility for genocide. Russia says Ukraine is responsible for committing genocide. Ukraine says it is not responsible, and that there is not even credible evidence for Russia's allegations. Article 9 says the court can resolve this question. Russia asserts that only one of the parties to this dispute, Russia, can ask the court to resolve it. But Article 9 plainly says that any of the parties to the dispute may submit it to the court. Any means any. The court should reject Russia's invitation to rewrite the treaty. If this textual deficiency were not enough, not a single decision of this court supports Russia's objection. The only jurisprudence touching on this issue favors the court hearing Ukraine's request. In Rights of Nationals, the court entertained France's submission that it find France acted in conformity with the relevant treaty. Similarly, in Lockerbie, the court did not dismiss Libya's request, as the applicant, for a declaration that it has fully complied with all of its obligations under the Montreal Convention. Russia labors to find factual distinctions, but these only confirm that Russia is inventing a doctrine purpose-built for this one case. The similarities are more striking and fundamental. Libya requested a declaration of its own compliance alongside claims that the United Kingdom breached the convention. Likewise, Ukraine asks the court to conclude that Russia breached the convention, and in doing so, to declare that there is no credible evidence that Ukraine violated the Genocide Convention. Lacking legal support, Russia offers policy reasons for creating a new admissibility doctrine. Russia chiefly objects that Ukraine's case preempts Russia's right to bring a case at the time of its own choosing. This is not fair, says Russia's counsel, because Russia needs time, quote, to collect evidence worthy of the esteemed court, end quote. Whatever weight this argument might have in a different case, it is shocking to hear Russia make it here. Russia claims to have been collecting evidence of Ukraine's responsibility for genocide since 2014. Russia launched a full-scale invasion on the basis of its allegation that Ukraine was committing genocide. If Russia concluded that it possessed sufficient evidence to warrant invading another sovereign state, it surely has had ample opportunity to assemble the evidence needed before this court, however much esteem Russia really has for the court. Russia also complains that this court is asked to sit as a fact-finding body. But Article 9 gives this court jurisdiction over any dispute relating to the Genocide Convention. When resolving such a dispute involves finding facts, this court can, of course, find facts, as it regularly does. Madam President, members of the court, I will conclude with Russia's sixth objection, that Ukraine has committed an abuse of process. As the court recently reiterated in its order admitting 32 interventions, quote, only in exceptional circumstances should it reject a claim based on a valid title of jurisdiction on the ground of abuse of process, end quote. There are no exceptional circumstances suggesting that Ukraine has committed an abuse here. In fact, Russia's allegations of abuse add nothing to its other objections. I will therefore be brief. First, Russia says Ukraine committed an abuse because it, quote, does not have a dispute under the convention, end quote. This is yet another objection that depends on Russia's false characterization of the dispute. Second, Russia accuses Ukraine of abuse by purportedly changing its claims. As I've already explained, Ukraine has not come close to transforming the dispute. Repeating this objection under the guise of abuse of process does not make it any more credible. Third, in its written pleadings, Russia called the timing of Ukraine's application abusive. Russia did not repeat the point yesterday, but suffice it to say that it is not surprising, much less abusive, that Ukraine would seize the court immediately after Russia acted on its false allegations of genocide to launch a full-scale invasion. Fourth, and finally, yesterday Russia repeated its argument that the interventions in this case constitute an abuse of process. The court has, of course, already rejected this claim in its order of 5 June 2023. Madam President, members of the court, Ukraine instituted these proceedings in the face of an existential threat, a full-scale military assault that it expressly justified on the pretext of abusive allegations of genocide. In these trying circumstances, Ukraine turned to this court. It reaffirmed its commitment to international law and peaceful resolution of disputes. Since then, Russia has continued to defy international law and to defy the authority of this court. Yet Russia accuses Ukraine of an abusive process. Russia says that Ukraine invokes the Genocide Convention as a, quote, pretext, end of quote. Ukraine's alleged abuse is seeking peaceful dispute resolution before this court. Russia's actual abuse of the Genocide Convention is a full-scale invasion of Ukraine. That difference says it all. Russia's sixth preliminary objection, like its others, must be rejected. All of Ukraine's claims are admissible. Madam President, I now request that you give the floor to Mr. Jonathan Gimblett.
I thank Mr. Zients. I now give the floor to Mr. Jonathan Gimblett. You have the floor, sir.
Madam President, members of the court, it is an honour to appear before you again on behalf of Ukraine. I will address the court's jurisdiction over Ukraine's claim relating to the Russian Federation's violation of the binding provisional measures order of this court. On the 16th of March 2022, the court indicated binding provisional measures to preserve the respective rights of the parties to the dispute. Among those measures was an order requiring Russia to immediately suspend all military operations in the territory of Ukraine. Since then, the Russian Federation has continuously violated the court's order. As Ukraine's agent described earlier, Russia's full-scale invasion continues to inflict suffering and death on the population of Ukraine to this day. In its memorial, Ukraine asked the court to hold Russia responsible for violating the order and to order it to make full reparation for the harm Ukraine has suffered as a result. Russia's preliminary objections asked the court to dismiss all of Ukraine's claims, but failed to explain the basis on which Russia believes that the court lacks jurisdiction to address violations of its order on provisional measures. Nor did Russia have much to say on the subject yesterday, its agent merely noting that the measures were preliminary and, in Russia's view, wrong, as if that alone excused Russia from heeding them. Madam President, members of the court, the disdain that Russia has shown towards a binding order of this court cannot be left without remedy. The court has the power to hold Russia accountable for its violation of the order and should use that power lest other wrongdoing states draw the wrong conclusion from the court's inaction. I will cover 3 points on this issue. First, and most obviously, Russia has a binding legal obligation to comply with the Provisional Measures Order. Second, the court has jurisdiction to address Russia's violations. And third, there is indisputable evidence that Russia has continued its flagrant violations of the court's order to this very day. I will begin with Russia's obligation to comply with the Provisional Measures Order. That obligation flows from Article 41 of the court's statute. As this court explained in Legrand, provisional measures orders issued pursuant to Article 41 of the court's statute have binding effect. The jurisprudence of this court since the Legrand case has consistently confirmed the binding nature of provisional measures ordered by this court, including in this case. Nowhere in its preliminary objections does Russia question the binding force of the court's order. Indeed, in other cases, Russia has expressly recognized the binding and mandatory nature of this court's provisional measures orders. It is therefore common ground that the provisional measures indicated by this court create a legal obligation for the Russian Federation. Russia's non-compliance with the provisional measures indicated in this case accordingly constitutes an internationally wrongful act engaging the international responsibility of Russia. I turn next to the court's jurisdiction to address Russia's violations, for which there are 3 independent grounds. First, it should be uncontroversial that where the court finds that it has jurisdiction over a claimant's substantive claims, it may address during the merits stage of a case claims relating to the violation of provisional measures ordered earlier in the proceedings. This much is clear from the court's judgment in Legrand, where the court explained that where it has jurisdiction to decide a case, it also has jurisdiction to deal with submissions requesting it to determine that an order indicating measures which seeks to preserve the rights of the parties to this dispute has not been complied with. As explained by my colleagues today, the court has jurisdiction over the present dispute relating to the interpretation, application, or fulfillment of the Genocide Convention. It therefore also has jurisdiction over Ukraine's claim arising from Russia's violation of the Provisional Measures Order. Second, the court has jurisdiction over Russia's violations of the order independent of its jurisdiction over the underlying dispute relating to the Genocide Convention. The court's jurisdiction to indicate provisional measures is derived from Article 41 of the statute, and in particular the first subpart of that article. By consenting to the statute of the court, a state consents to the court's exercise of that power. As Judge Abraham's separate opinion in Qatar versus United Arab Emirates explained, the court's jurisdiction to entertain a request for provisional measures for its part does not derive from the jurisdictional basis invoked in the proceedings on the merits. It is based directly on Article 41 of the court's statute, which gives the court the power, when seized of a case, to indicate any provisional measures which ought to be implemented to preserve the rights of either party. This basis of jurisdiction is entirely independent of that relied on by the applicant or by both parties in the context of the principal proceedings. The court's jurisdiction to make findings about breaches of provisional measures derives directly from its power under Article 41 to indicate such measures in the first place, and is independent from the court's jurisdiction to adjudicate the merits. Inherent in the jurisdiction conferred under Article 41 of the statute is the power not only to indicate provisional measures, but also to monitor compliance with them and to adjudicate alleged breaches. A restriction on the court's ability to address violations of provisional measures, independent of the merits, would be inconsistent with the object and purpose of the statute to ensure the peaceful settlement of disputes and the effective administration of justice. Indeed, Article 41 would be deprived of its effectiveness if the court could only hear claims for violations of provisional measures after a decision to exercise jurisdiction over the underlying substantive dispute. If that were so, recalcitrant states would be encouraged to ignore the court's orders on provisional measures in the hope of prevailing on preliminary objections. That the court may determine non-compliance with provisional measures independent of its jurisdiction over the merits finds support in the court's jurisprudence. In request for interpretation of the Avena judgment, Mexico sought to invoke the court's jurisdiction under Article 60 of the statute and requested provisional measures. While the court indicated provisional measures, it ultimately decided that the question underlying Mexico's request for interpretation is outside the jurisdiction specifically conferred upon the court by Article 60. Nonetheless, the court concluded that it had incidental jurisdiction to make findings about alleged breaches of the order indicating provisional measures, and that jurisdiction existed, quote, even when the court decides, upon examination of the request for interpretation, as it has done in the present case, not to exercise its jurisdiction to proceed under Article 60, end quote. The same conclusion holds when jurisdiction over the substantive claims is sought not under Article 60, but, as in this case, under Article 36. In short, even setting aside the question of your jurisdiction over Ukraine's substantive claims, you may address its claim for violation of the Provisional Measures Order. Third, the court has another independent ground of jurisdiction to address Russia's violation of the order pursuant to the compromissory clause of the Genocide Convention, Article 9. Under that article, Russia has assumed an obligation to comply with mandatory procedures and to do so reasonably and in good faith. By agreeing to submit disputes under the Convention to the Court, Russia has agreed to comply with the Court's procedures, including any decisions issued by this Court, such as on provisional measures. I will now briefly recall the overwhelming evidence that Russia has continuously and flagrantly violated the Court's order of the 16th of March 2022. In that order, the Court required Russia, first, to immediately suspend the military operations that it commenced on the 24th of February 2022 in the territory of Ukraine, and second, to ensure that any military or irregular armed units which may be directed or supported by it, as well as any organisations and persons which may be subject to its control or direction, take no steps in furtherance of the military operations. The order further required both parties to refrain from taking any action that might aggravate or extend the dispute. There is no question that Russia has completely disregarded the Court's order. Indeed, Russia's non-compliance has been expressly admitted by Russia itself. Just one day after the Court indicated provisional measures, Dmitry Peskov, the official spokesman for the Kremlin and press secretary to Russian President Vladimir Putin, stated that Russia will not be able to take this decision into account, I quote. Such disrespect is an affront to the integrity of this Court and the UN system of which the Court is a part. Russia's flagrant non-compliance with every measure indicated in the Court's order has been plain for the world to see since the day the order issued. It is common knowledge, confirmed by the reporting of international organisations and major international news outlets, including statements by Russia's official press agency, TASS, that Russia's military operations in the territory of Ukraine remain ongoing. Russia's continuing full-scale invasion necessarily violates the Court's first and second provisional measures. Put simply, Russia has not suspended its military operations in Ukraine. It has extended and intensified them. Nor has Russia ensured that military or irregular armed units that it directs or supports, or organisations and persons subject to its direction and control, take no steps in furtherance of the military operations. Instead, Russia has drafted tens of thousands of young men and sent them to fight on Ukrainian soil. Russia's conduct also violates the Court's third provisional measure by aggravating and extending the dispute between the parties. As you heard from Ms. Cheek earlier today, the dispute that Ukraine has brought to the Court concerns the use of false allegations of genocide as a pretext for aggression against a neighbouring state to bring that alleged genocide to an end. When the Provisional Measures Order was issued on the 16th of March 2022, Russia claimed to be engaged in a so-called special military operation with the specific goal of punishing those responsible for the falsely alleged genocide in Donbass. As Ms. Cheek also described, Russia continues to rely on its false allegation of genocide to justify its intervention in its neighbours' affairs. But since March last year, Russia has intensified its assault on Ukraine, resorting to the use of ever more destructive weapons and tactics, and deploying them increasingly against civilian targets. When I last addressed you in this case, during the hearing on provisional measures, Russia's military was pushing towards Kyiv in an apparent attempt to decapitate Ukraine's democratically elected government. Evidence of war crimes against civilians was already emerging, and more was to be uncovered in the following weeks after Russia's brief but deadly occupation of towns near Kyiv, including Bucha and Irpin. The Russian military was deploying indiscriminate weapons in its attempt to quickly overwhelm the country's defences, including cluster bombs and Grad multi-launch rocket systems. Russian shelling had damaged a training facility at the Zaporizhzhia nuclear power plant. "18 months on, Russia's military operations have not only continued in defiance of the court's order, they have intensified, exposing the vulnerable Ukrainian population to ever greater risks and hardships. After the failure of its initial assault on Kyiv, Russia has resorted to the most destructive forms of modern warfare, eradicating whole cities like Mariupol through concentrated artillery assaults, using weapons of enhanced lethality such as barrack shells and hypersonic missiles, and repeatedly targeting Ukraine's infrastructure in an attempt to break the country's economic backbone and intimidate its people into submission. Russian forces now physically control the Zaporizhzhia nuclear power plant, the largest in Europe, and they've used that control to engage in a form of nuclear blackmail, including by placing objects resembling explosives on the roofs of buildings at the site. And the war crimes and human rights abuses that have been a significant feature of Russia's campaign from the very start have reached new levels, to the point where the International Criminal Court has issued an arrest warrant against the President of the Russian Federation for his involvement in the mass deportation of Ukrainian children to Russia. Russia has further aggravated the dispute between the parties through its purported annexation of the oblasts of Donetsk, Luhansk, Kherson and Zaporizhzhia on the 30th of September 2022. This represents a step change from the situation that existed as of the 16th of March 2022, when the relevant aspect of the dispute was limited to Ukraine's claim that Russia's recognition of the Donetsk People's Republic and the Luhansk People's Republic, based on a false claim of genocide, was an abuse and violation of the Genocide Convention. The attempted assimilation of Ukraine's sovereign territory into the Russian Federation is an unambiguous infringement on rights that the Provisional Measures Order was intended to protect. In short, Russia has not only failed to comply with the court's order, it has explicitly rejected this court's binding order and defied each and every measure the court indicated. It is telling that in the face of this clear evidence of its disrespect for both its international obligations and the court, Russia has nothing to say. Exercise of this court's jurisdiction to address non-compliance with the Provisional Measures Order is particularly critical under the extraordinary circumstances of this case. Russia's defiance of the court's binding order represents a blatant challenge to this institution. If left unaddressed, such conduct risks making the court dependent on the goodwill of the parties It can hardly be reconciled with the position of the Court as the principal judicial organ of the United Nations. As Judge Wiramantri observed in the Bosnia genocide case, to view the order made by the Court as anything less than binding would weaken the regime of international law in the very circumstances in which restraining influence is most needed. This brings to a close Ukraine's opening oral submissions. As my colleagues have detailed over the last few hours, Ukraine has brought before this court a dispute that falls squarely within your jurisdiction under Article 36(1) of the Statute of the Court and Article 9 of the Genocide Convention. The correct course is for the Court to dismiss Russia's preliminary objections in their entirety and proceed to the merits, where Ukraine's Article 41 claim for Russia's violations of the Provisional Measures Order can be addressed alongside its substantive claims. Ukraine thanks the Court for its attention.
I thank Mr. Gimblett, whose statement brings to an end this morning's session and the first round of oral argument of Ukraine. The Court will meet again tomorrow at 10 a.m. to hear the oral observations of the intervening states. Sitting is adjourned.